Hafade, welcome to the Guam Congress Building. The Committee on Health, Land, Justice, and Culture is now called to order. Today's February 6, 2024, and the time is 10:05 a.m. In compliance with the open government law, notices for this public hearing were published in the Guam Daily Post and posted to the Government of Guam public notice portal on Tuesday, January 30th and Friday, February 2nd, 2024. Notices were also sent by email to senators and all main media broadcasting outlets. This hearing is being live streamed on the Guam Legislature's YouTube channel. We have one agenda item for this hearing at 10 a.m. It's the Bill number 228-37 COR, introduced by myself, Therese M. Terlaje. It's an act to amend Section 75A 109A of Chapter 75A, Title 21, Guam Code Annotated, relative to successors to CHAMORRO Land Trust leases. As the primary sponsor of the bill, I'm going to introduce it briefly. So this bill number 228 was introduced to tackle a long-standing challenge within the CHAMORRO Land Trust Commission, specifically addressing limitations in defining the successors of the CHAMORRO Land Trust leases. The proposed amendment to Section 75A 109 empowers the lessee to designate a broader range of relatives as successor to that lease. In addition to spouses, children, widows or widowers of the siblings, or nieces and nephews, which is listed in the current statute, according to this bill, the lessee would be able to designate grandchildren. Since introduction of the bill, we have discussed this with CHAMORRO Land Trust Commission, and we have noted that the bill should actually add parents, siblings, and widows or widowers of the children, in order to be consistent with other rules, fairer, and to make more sense. We also noticed that the same issues affecting lessees also affects applicants who die before their applicant is completely processed. So this, we are also considering allowing applicants to be able to pass to include grandchildren, parents, siblings, and widows or widowers of the children. In changing the statute, we also noted that we should probably make corresponding changes to the rules in 18 GAR 6A132 and 68112, which currently cite the statute. That is so that there would be no inconsistency, and the CLTC can act immediately after passage of this bill to process applicants that are before them. I hope that we can discuss these corresponding amendments to the bill today and include these amendments in the final version as well. So I hope to get the bill out of committee as soon as possible so that it can be placed on the February session agenda. The CHAMORRO Land Trust Commission has temporarily paused certain processing of applicants pending resolution of this issue. The fiscal note came from BBMR. It says the bill is administrative in nature and poses no fiscal impact upon any funds of the government of Guam. I'd like to thank my colleague, Senator Joanne Brown, for being here with me this morning. Senator Brown. So if there's anyone who'd like to testify on the bill, we have signed up Mr. Joey Cruz on the CHAMORRO Land Trust Commission, and of course the chairman, Mr. David Herrera of the CHAMORRO Land Trust Commission. Thank you for being here. Mr. Chair. Mr. Herrera.
Buenos dias, Madam Speaker and Senator Brown. Dank u na Jesus Masi na propone este na bill bill number 228-37 na anno si David Babauta Herrera guaho segundo siza gi CHAMORRO Land Trust Commission. No magard na este na bill ta propone para ta arreglesti para manahalo minieto na patgun gwinigi aplikante na munera sa imapus na lai sa ileg nga ilesi non sina no transferi i offer na para beneficiary. Lo magahit na 30 años disitotigi 1975 no guaha 8,000 man manaplika gi para Chamorro Land Trust zagi 8,000 na tauto man godunit gi minat size no in the basic English language I was mentioning that no since 1975 we accumulated about 8,000 applicants, and out of 8,000 applicants we basically were stuck at number 6. Imagine, back 1975, that was like 30 years ago, and we were stuck at number 6. Fast forward to today. I thank you, Madam Speaker, for putting this in your radar, in your agenda, so that we can unclog this bottleneck on number 6. Once this number 6 is resolved, what this would do to the Chamorro Land Trust process flowchart is that it would open the 8,000 applicants that are awaiting to be processed. Now, the process methodology is very tedious, as we understand that we had Chapter 75 that was modified or enhanced to Chapter 75A that included additional qualified beneficiaries. So that being said, we understand that with the 8,000 applicants, and in addition to the 2,900 lessees, we still have a large challenge to approach, because a lot of these lessees that were provided a lease still have these challenges of transferring their interest to their grandchildren. Now, that being said, we have to look back and look at the 8,000 applicants that are still being processed, that are now reaching the age of maybe 60 years old, 70 or 80 years old from the time that they applied back in 1975. So that being said, this bill that is being proposed, I would like to say that I testify in favor of Bill number 228-37COR, and that to include the grandchildren as a successor. Thank you, Madam Chair.
Chairman, Commissioner Herrera. Mr. Cruz.
Good morning, Madam Speaker and Senator Brown. My name is Joey Cruz. I am here today by the oral testimony of the Acting Administrative Director, Mr. John Birch. I am here today to testify in support of Bill 228-37, which proposes important amendments to the current legislation regarding the designation of heirs and succession rights for Chamorro Land Trust lessees. I recommend amending the bill to include grandparents, parents, siblings of the lessee, and successors of applicants as designated heirs. Furthermore, I strongly recommend the retroactive application of these provisions from the effective date of the law. First, I believe it is crucial to include grandparents, parents, siblings, and grandchildren of the lessee as designated heirs in the legislation. Immediate family members play a significant role in the lives of lessees, and grandparents, parents, grandchildren, and siblings often provide invaluable support, care, and guidance. By including them as designated heirs, we acknowledge the significance of extended family relationships and ensure the protection and recognition of their rightful interests within the Chamorro Land Trust program. This inclusive approach fosters strong family connections and promotes a sense of unity within the community. I also recommend including successors to applicants and lessees as designated heirs and making this inclusion retroactive from the effective date of the law. The proposed amendment should encompass the successors of the lease applicants, ensuring the protection and recognition of the rights and interests of these individuals. By extending the designation of heirs to successors, the legislation acknowledges the evolving nature of family structures and provide a comprehensive framework for the transfer of interest in the event of the lessee's death. The retroactive application ensures that all families, both present and past, are afforded equal opportunities and protection under the law, promoting a sense of justice and equality within the Chamorro Land Trust stakeholders. In conclusion, I strongly recommend amending Bill 228-37 COR to include grandparents, parents, and siblings of the lessee, as well as successors of applicants or lessees as designated heirs. I also urge the retroactive application of these provisions from the effective date of the law. These amendments will strengthen family ties, recognize the contributions of extended family members, and rectify any historical inequalities. By adopting these amendments, we will ensure a fair and inclusive system that reflects the values of justice, unity, and respect within the stakeholders of the Chamorro Land Trust Commission. Thank you for your attention to this matter.
Mr. Cruz, and to the Acting Director Birch for your testimony. I want to note that we've also received written testimony from Lydia Terlaje from in regards to the bill as well. All right, and I want to note, so her testimony suggests that we should expand the bill to include parents, siblings, and grandchildren, and remove the widows and widowers of the brothers and sisters. I'm just picking up portions of the testimony. It says, I feel the widows and widowers of the brothers and sisters should be removed from the line of successors. If a lease is transferred to an in-law and the in-law remarries, the widow or widower could name the new spouse as a successor, and this action would move the lease out of bloodline. And then she talks about why we should expand the list to include parents and the siblings and the grandchildren. Allowing a parent to have applicant's rights is like naming a parent to your beneficiary and your life insurance, including grandchildren as a successor to application and or lease rights is important. Guam's history includes dark times when grandparents have had to step in to take care of the grandchildren when the parents could not. The heroin years in the 70s and ice epidemic had parents dying, and the grandparents stepped up and raised the grandchildren. During the period with the gambling parlors, children were left in cars while parents were spending all the money. Once again, the grandparents had to step up and raise the grandchildren. If a grandchild can't inherit the application or lease rights, the rights will go to the unfit parents would abandon their children. Visit an agricultural lease lot, and mostly it is the grandchildren who are helping their grandparents farm the land, not the parents. Please note, I have included application rights. The public law has changed the 18 GAR administrative rules. Whoever codified the public law has removed the section 6112, application for leases, transfer of application rights, killing the application's rights at the death of the applicant. All right, so as I talked about earlier, thank you to Ms. Lydia for your testimony, thank you to the Acting Director for submitting his testimony, and of course in my discussions with the chairperson, I agree, and I agree that we should expand not just to grandchildren, but to parents, to the siblings of the lessee and the applicant. So current law allows, succession of lessees for sure. It allows, and it looks now like the succession of applicants was in question. But originally, under the original law, it had always been allowed. So I would like to continue that, to allow succession, to make it more in line, like parents, yes, of course, they should be included. It was allowing for widows of the brothers and sisters, but not the brothers and sisters themselves, so of course they should be included, and grandchildren. And so I agree with that. That's my intention with this bill, and your testimony is very helpful. I guess if I could ask you something, Mr. Cruz, my question is, in your testimony you asked that it be retroactive from the effective date of the law. Which date are we referencing there? Is that the January 2001 date? and why would that be helpful?
Even prior to January 1st, 2021, unfortunately, we do have some leases that were awarded to grandchildren. So even prior to the amendment or the settlement agreement with the federal government, grandchildren weren't eligible in the line of succession. But we do have some leases that were awarded to grandchildren.
Okay, so what date should that be? Maybe if you could submit that to me, or we have to cite which law now, right? You're talking about the original Chapter 75?
Yes, ma'am.
Okay, all right, got it. And then, will the changes that are being proposed to Chapter 75A and the rules, if I change the rules as well, in Chapter 6A, those are all the new rules and the new code, suffice, or do we need to change the old versions in Chapter 75 and Chapter 6? Those are prior to the lawsuit.
I think changes to both will provide clarity for us.
So you still process some applicants pursuant to the old laws and the old rules?
No, ma'am. The original Chapter 75 and Chapter 6 in the GAR applies to leases that were approved and awarded prior to January 1st, 2021. Moving forward, we apply the Chapter 75 and Chapter 6A in the GAR to any leases awarded.
Okay. So this would, we would need to apply this to Chapter 75 lessees, but do we have any Chapter 75 applicants then, or no more? No more?
No, we shouldn't.
Okay. And, all right. So I know I gave you a draft of a bill that I'm proposing to make the amendments that you are suggested. I also gave a copy to Senator Brown, and I'll give to any other senators. Oh, I'll give to, oh, thank you, Senator Roy. I'd like to recognize Senator Roy Canasta. Thank you for being here, Senator. And I'll open it up now for Senator Brown. Any questions or comments?
Thank you very much, Madam Speaker. I wanted to inquire, in terms of, you mentioned already that the Land Trust has already passed on land to a grandchild or grandchildren. Has that been a challenge with regards to an original lessee that has passed on? Do they all designate who they want to have their lease transferred to within their family? Or how's the Land Trust going about addressing those issues?
Currently,
And then how do you select if more than one wants it? If you have children or grandchildren, and how does the Land Trust determine, especially if the leasee may not have left, designated one in particular? Because I don't know why that is, but some Chamorro families, and it was the case in mine, they didn't want to make the choice to choose one over the other, because it's like you're favoring one and not the other, and then you can't equally give to everyone. So I just wanted to ask, how have you guys been addressing that?
currently, we have a designation of beneficiary form that a lessee will fill in or fill out, identifying who they would like their successor to be. Although the lessee is advised now that their grandchildren is not in the eligible line of succession. Back then, based on what we see or what we saw in files, is lessees were and did name a grandchild, and it was approved by the acting director then, or the director at that time. But moving forward, now the commission advises the lessees of who is eligible in the line of succession. And if there is named more than one beneficiary, we also advise them of the hurdles or obstacles we may address. If the lessee shall not designate a beneficiary, the board, based on the act, has the authority to designate a beneficiary, but within the line of succession. And if we come to that point, then that case is presented. If there's a family member who submits a letter of interest within the line of succession, that information is also provided to the board for their decision making.
So then ultimately, the commission can decide from the line of succession. If there's more than one applicant, it will be the commission to decide who they will designate.
We try to get the family's concurrence before presenting it to the board. Normally, for example, if there's 4 siblings or 4 children, they usually waive their interest to someone who they feel is capable of complying with the lease terms.
And then do you guys also ensure that with regards to the property, that they're in compliance or have been in compliance? Because we know the list is long of leasees that are not following the requirements, be it, for residential or most definitely for agriculture. See a lot of abuse. I mean, they're growing houses and junk cars and tires. They're not growing trees and fruits and vegetables. So at the time of these transfers, are you guys verifying whether or not the lot is in compliance with the Chamorro Land Trust requirements?
We do conduct compliance inspections. If in the event it's determined that the lessee or the leased property is not in compliance, we do provide the beneficiary or successor at least 60 days to show progress to come into compliance prior to any presentation to the board for conveyance of that lease.
And so the lease has to remain with a single individual, because some people are under the impression, especially parents that had more than one child, they think that once they have this land, they get to subdivide it among their children as if it's their own personal legal property. I'm sure you've encountered that.
For past leases that were awarded, there is husband and wife. There is multiple people on a lease. But moving forward, after our guidance provided by one of our previous attorneys, there is only one person now on the lease.
And so are you addressing that as these issues come up, or are you guys going back into your records and where you see multiple names listed, are you addressing correction or only as they come before the commission? How are you going about addressing those issues?
We address it based on when it comes up. Although it is known, but there is an intention to circle back and start from day one and move forward while simultaneously moving the line.
If a leasee passes away and they hadn't designated someone, but there are others in the family that were in line of succession, are they able to come to the commission, make a request for that particular lot lease, or how do you address that?
If the lessee hasn't designated a successor to their lease, and a family member who is within the line of succession does submit a letter of interest, or even physically make claims or provide interest to taking over, we will receive the information, prepare a staff report, and present it to the board. But we also try to inform the children of that lessee.
Do you also require, of course, because I mean, we have a lot of situations now where the children or grandchildren live off island. That's it's sad to say, but that's a reality for many local families here. Would they be required, I mean, whoever receives this, for example, that inherits this lease agreement, wouldn't they be required to be on the property? And if it's an agricultural lot, they still have to be there to farm it, so that they're not sitting there thinking they just get to hold on to the property and it sits there. I mean, aren't they required to, again, comply with the lease agreements?
For as long as the lessee is complying with the requirements, for example, like agriculture, if the agriculture lot is being farmed by 2/3, and the lessee requests through the commission that they are authorizing cousin A to maintain the property, and approval is given, then it's an approved action.
Okay. I know we could go on all day. I know there are a lot of issues, but I thank you for your testimony, for both of you, and giving our community additional insight, and I wish you well. I mean, I think ultimately we want to see compliance with the land trust requirements. I know the sins are long and far and deep, but as time goes on, I think as we see more compliance and those that have received these lots are following the requirements, I think we'll have some sense of comfort, because again, there's been such flagrant abuse at all levels with the land trust. And we want to see, especially for those, because there are many Chamorros that will never have the opportunity of having this property to ever live on or farm for their families. I mean, even if it's for subsistence, they can, they can grow their crops and their trees and everything and even if it's just simply for their own subsistence, that's perfectly fine to stay in compliance. And we want to see that because, like I said, many will never have that opportunity. And I hate to see the abuse of those that have been given the opportunity to have these properties. So thank you very much to both of you for coming in and providing your insight and your testimony. It's most appreciated. Thank you.
Thank you, Senator Brown. Senator Kanata.
Thank you, Madam Chair. Thank you to the panel for being here. Certainly want to support the Chamorro Land Trust in its endeavors to, help our land lease, our tenants find their properties or situate themselves. I do have concerns regarding the 60-day notice alongside with this awarding of grandchildren. In the regards to adopted children that are not of blood, is that still honored, or does this legislation need to include that?
I believe if there's legal documents that are provided that the individual is a child, that should suffice.
Okay, thank you. Also, with the compliance, what if the individuals are not even using the property at all? Is that a part of compliance? Like 60 days, they haven't been there. 20 years ago, they haven't been there. I mean, I am 27. The program started in 1995-96, right? The Chamorro Land Trust was in a program to help our people grow and, be prosperous on our island. And a lot of them are not using these properties. So I think it's time to also ask them what's their status. It's not gonna gain interest. It's not yours, it's the government's own still. The general people that honestly need this should be availed to those opportunities. There's properties that have water and power access that are not being used. Where those people are, I don't know. But I think it's certainly time that we need to address these people who are leaving these lands vacant and unoccupied, that if you don't have any motivation to move on this property, then I think it should be re-lotteried and given to the next person, because we have a long list. I date 27 years. If I apply today, 27 years later, I probably won't even get it. Not intending to, blame you guys. I certainly understand that you guys have your challenges, but I think updating the records is also a difficult one. But I think people need to recognize that this property needs to be used or lose it. You know what I mean? So I hope that that's also looked into alongside with this legislation. And also, what is the timeline on you guys awarding of the next person? Is there any update? I do watch your, Mr. Chair, I do watch your board meetings quite frequently when I have time, and I also try to chime back in when I miss it. But, do you think it's, you have legal counsel from the Attorney General, but you guys have so many land issues, land matters that need to be litigated. Do you find it important, or do you think it would be great for you guys to have your own legal counsel outside of the Attorney General's office that can actually make some legal decision, not table it to the next meeting? Because I certainly feel the disappointment within the board that a lot of times, let's just table it to the next meeting, Mr. Chair. Let's just table it to the next meeting, Mr. Chair. And quite frankly, 27 years later, we're not tabling anything. We need to move on and find progress for our people, because generations are going to come and generations are going to go. Mr. Chair.
Dankuluna Sizus Masi, Sinidot. Anyon sangan is the update no 30 años tati no gi 1975 no ta establisa a first come first serve. So 30 years fast forward, we have 8,000 applicants. So I'll merge with your update. So here's my plan, is to take the 8,000 names plus the 2,900 names, lay down in a spreadsheet, and meticulously go lessee applicants line by line and get an update, like you mentioned, an update. how are we going to do this kind of task with only 7 people in the Chamorro Land Trust? So I have tied in with Dr. Therese from University of Guam and his MBA students, and we're setting up a platform to lay this out in a concept where we're going to do a mass public outreach. We're going to do it section by section, because out of 8,000 plus the 2009, we have approximately maybe 9,000, maybe 10. And what we want to do is categorize and subcategorize each and every individual that applied. Why? Because right now, we can say we have 8,000 applicants, and we have 2,900 lessees. Who are they? Do we know? Like the senator mentioned, do we know if they're on the property, or have they vacated the property, or have they modified the property where one lessee now is hiring other external joint venture farm operation? And I'm pretty sure some of you guys understand what I'm saying. And they market the product out in the farmers market, not from our lessees, but from the auxiliary labor that they bring in. But let's get back to the 8,000 and 2,900. Why do we want this data? The reason why we want this data is that right now, 30 years fast forward, we have about 11,000 properties. Chamorro Land Trust has not built one home. None, zero, taza. Why? How can you, right, compute and project that you have 11,000 acres? I would say maybe that's about $1 billion cash, and you have not built one home, not one. And you have all the federal programs, right, from the USDA, Farmers Home, VA, Guam Housing Corporation. And back then, when we were protesting this down at Adelup, we had this vision, right? So the vision was that to have this amount of real estate subdivided accordingly, set up the water, power, sewer at the expense of the land trust, not at the expense of Tunuse or Tan Maria, and that's what we're doing now, right? You want to put up a telephone pole, Tunuse and Tan Maria, right? That would be $8,000, $8,000, right? You want to put a sewer water, add another $10,000. Really, with the average income now, at the cost of living now, or the cost to construct a home now at about maybe $200 or $250 a square foot, you could survive at a $50,000 income, or even the income of a $100,000 salary with 1 child, 2 child. Some household have 13 children, right? You compute that. And out of 8,000 applicants, 2,900 lessee, we cannot build one home. That is unacceptable. Where did we drop the ball, right? Of course, it's the leadership. We were talking about number 6. We're stuck at number 6, but yet we have 2,900 lessees. How can you compute that? Is that logical, or is that a fraud, waste, or abuse? Right? So how can a person that's at number 800, a person that came in at number 2,000, get at least ahead of the person number 6? Right? This is very simple, right? There's so much gray area. There's so much. We have people that do their own legislation within the land trust. We have people that do their own rules and regulations within the land trust. This is where all these fraud, waste, and abuses are coming up. Fast forward to today, right? So when we do that outreach, out of the 8,000 applicants and the 2,000 lessees, we're going to be asking other questions, other demographic questions that are relevant, that would be interrelated to utilizing federal programs, integrated into the Chamorro Land Trust program. Can a VA build on Chamorro Land Trust that's $1 a year? Yes. right? Can a person earning $100,000 build on Chamorro Land Trust? Yes. Can a person earning $20,000 build on Chamorro Land Trust and have a home? Yes. Can we do a turnkey concept? Yes. But where's it today? 30 years, fast forward, right now. And if you look at the inventory, you know, we can spread it out here. And you have people that have built that are from the VA, people that have built from the past typhoons. From the past typhoons, we have 100 constituents. Correct me if I'm wrong, Joey. Out of 100, 19 defaulted, bankrupt, 19 on a small business administration loan. Typhoon Mawar came, right? We started with how much? Did we have 300,000 in the kitty? Right? 300,000. So the new constituents, right, that came in, maybe 25, they were each approved about $240,000. So out of 240, right, because they were living on a land trust property at $1 a year, we have to guarantee the loan. Sure, by record, I made a motion that we're going to use the 300,000 to secure the $2.5 million. It was shut down. My other colleagues were afraid to get sued, personally get sued. So I'm saying, okay, all right, so if you are afraid to get sued, are you personally liable that after you have approved, I'm talking about the members now that had their signature to approve these loans or leases out of the 2,900, and remember, we're still at number 6. So who do we blame of all this non-compliance? The lessee or the people managing the program? Right? So right now we're saying, you, Tunise, you're in non-compliance, you got 20 demerits. You, Tan Maria, you got 30. We cannot approve your loan. But who really did this process, right? They were depending, the constituents were depending on the professionals in the Chamorro Land Trust. So we give them this authorization. You can occupy, you can ranch. And then now, fast forward, oh, you're in compliance. We need to put a stop, work order, cease and desist. That's hypocrisy. That's hypocritical. And who do we put the burden on? The constituents. Us that were living in the office, air conditioned, we got rocking chairs, we got laptop, all these fancy components, right? But yet our constituents that were beneficiaries from what happened to their parents way back are now the victims. Well, it's not going to be like that. Because once we finish the 8,000 and 2,900, as I move this forward, I already have the plan, and I only got on board being a vice chair last several weeks. But this thought we have worked on since 1995, since we stayed down at Adelup. So 30 years now. We're stuck at number 6, and I applaud the speaker for saying, okay, why are we stuck at number 6? Because the applicant designated the grandchild, correct, Joey? Joey would attest because we were together back 30 years ago. He was our runner, and I was his activist. Most of our activists passed away. Ongit passed, Benavente passed, Mataga passed, Pangilinan passed. So Joey's here, and we bumped heads together, but I said, hey buddy, remember, our cause is for the people. Right, Joey? So this is a new team, and I pray that we work together because we need some of the legislative modification we need to integrate all the federal programs and all the rules and regulations. And I was asking the speaker, can you please explain to me, this language here, because some of them are new to me, this jargon of policies and amendments and retractment. But we can make the program work. Honestly, we can make the program. Give me some time. and we're going to build not one home, but we're going to, when it's done, then we'll show it. But right now, the planning stage has been set, and we have to reach out to the 8,000 applicants if some of them are still alive or they have passed, and the 2,900 lessees, and we're going to have to get some data. We need data to support our movement with the federal government, because the federal government is not going to just give us $500 million to do the project. They need data, factual data, and to prevent fraud, to prevent abuse and waste. So that's it, Senator Q.
Thank you, Mr. Chair. What else? I mean, what about reared children? Is that covered? Reared children?
Malig nun sa akin yun man mapuksay sa reared children, and you did ask if they were bloodline through genealogy or are they just reared from, and that would be, you guys are the professional in the language. Even with this first cousin, second cousin, I think Joey says it, what was it, third consanguinity. So I'm thinking that would be first cousin, second, and third cousin. Would that be a correct definition of that vocabulary?
I'm guesstimating in the instance for gunkles, gay uncles, right? We don't have children. We're not in the So if I raise my nephew or niece, and I wanted to surrender the property to that individual, who he or she be, would I be able to or not?
Yes.
Or does that need to be included here?
Yeah. Well, what's the key here, right, is to understand what was the origin of the Chamorro Land Trust. Remember that we started back in 1898, and those properties that have been condemned unjustly up to 1968 were in that window. Now, if the children or rear children were not part of that lineage, that would be best decided by the body here. You know what I mean? You guys are the experts in this program. We can submit our recommendation, but again, we have to stay focused, right, on what created the Chamorro Land Trust, what created the land use program. And this is what I wanted to add, is that in 1950, right under this roof, when they passed the Organic Act, and the Arrendo program started, the land use program. You may recall, right, Arrendo? So many of us, including myself, were landless. Our property was totally, we didn't have property. It was condemned properties in Fenna or Sumay or Hogat, and we became landless. So back to the point that you're saying, if I adopted Joy, for an example, right? That's a South African from apartheid. Would
not
he
adopted, just reared.
Reared, yes, yeah. But by law, I officially adopted him wherever he came from. If he's the line of Mandela or Mahatma Gandhi, but he is now under my line legally. So you guys have to filter that out. Would that be related to the original cause of the problem, that was of the properties that were unjustly taken? By law, yes, right? But by spirit, you guys would want to probably hash that out.
Okay. Thank you, Mr. Chair. Ms. Joy?
Senator, if I may, if your reared children is your nieces and nephews, from your brother, from your siblings, they will fall in the line of succession. The current line of succession does include nieces and nephews, which we extend up to the third consanguinity of relation, which is the children of your siblings.
Duly noted. Thank you, Mr. Joey. Madam Chair, that's all.
Sidusmasi, Senator Caneta. Mr. Chair, you are singing my song. Sidusmasi. Senator Taitagui.
Actually, you answered my question on a lot of questions I had, Mr. Chair, and I greatly appreciate it. And thank you so much for your hard work and dedication to the trust. There was a question asked, Joey, from Senator Brown earlier with regards to, how do you determine if there's more than one person on as a beneficiary, like in the past, right? So when you say line of succession, I didn't really hear the answer on who would actually get the property, because it could only be one. So let me give you an example. So the lessee passes away, and the beneficiary has both of their children both children on the as a beneficiary, right? And now the land trust, keeping in line with all your rules and regs and trying to, insert accountability and making sure that this happens. Like you said, Mr. Chair, they were creating jungle rules at the land trust, and now that has to stop. So and that's what we're here today to ensure, we put things in law. There's no confusion about it or contradictions between the Guam Code Annotated and the rules, right? That's what we're here today. So when you say line of succession, now the land trust has to decide which of the two that are on the beneficiary that was asked, which would go first. Now, do you base that on like who's the oldest child to get that property, or because if they both want it, let's say they both want it, and they're not going to waive their rights, like you said, other siblings will waive their rights, but let's say they both want it. Now it becomes a family feud, So 2 children, how do you base it on when they both want it? Is it by age? Who is born first? And then the second one, I mean, they have the credentials are all the same. They're all willing to do exactly what the lease agreement agreed to, growing not cars or houses, but, vegetables and fruits.
If the property is large enough to subdivide, that is something we would recommend to the board. For example, if the lessee had an acre lot and it could be subdivided into 2, that's an option we'll present to the board. But currently, since my time in 1998 to present, I have not encountered the example that you had provided us. We will provide all the factual information to the board, and it will be left up to the board to decide who.
Yeah, that could be some favoritism or something happening underneath the table if you do that. So I think that we need to address that. I mean, there's always a first time. We want to be proactive. You don't want to get in a situation where something like this happens and it's never addressed. You want to be able to answer these questions right away. So if you talk about line of succession and you have siblings, I think that, if they both meet the same criteria, that the last option would be either if they agree to subdivide, which does allow it, right, Joey? You're saying there is some subdivision that you can do?
If the property is large enough.
Okay, yeah, like 1 acre, for instance, okay. But if it's not, you have to come into that situation. So it's subdivided, that's good to know if they agree upon that, or, well, they don't have to agree upon it because the eldest, and then if you go to the eldest son or daughter, that might be an option too. So, yeah, I'd like you guys to ponder on that, on what would be the best choice to make a decision on that, okay? Even though it hasn't happened, I'm glad to hear it hasn't happened, but I'm telling you, land is getting tight nowadays, and a lot of people are desperate. And Mr. Chair, yeah, I really want to look into this thing where, not one house has been built on it. I don't know if there's other restrictions that avoid from anything like tiny homes or, using other affordable houses on Chamorro Land Trust. But I know a lot of it has to do with infrastructure, and the costs in that. But thank you for that great information. And Joey, thank you so much, too, for your hard work. I appreciate it. Thank you. Thank you, Madam Chair.
Jesus Mosley, Senator Titlegy. Senator Senator Barnett.
Thank you, Madam Chair. Thank you, Chairman Herrera. Thank you, Mr. Joey, for your testimony. And again, I commend the effort this legislation is making, because you see, I mean, I think we see the intent of the Chamorro Land Trust, right, at its inception, and I commend you, Mr. Chair, for pushing that agenda. And I just got to think it's a big victory to have you at the Chamorro Land Trust, right? Because who better than one of the activists who helped form this and push for this, right? And again, I commend the legislation, because we have to fix this system at the Chamorro Land Trust, because I'm bothered by what I hear out there, which is, right, the demonization of the Chamorro Land Trust, the lessees, the people talk about the conditions of some of these lots that we're leasing out. And so that's why I think it's important that we continue to correct where we can, so that we can give these lots out, because there are many people, unfortunately, on our island who are salivating when they look at the Chamorro Land Trust inventory, and they say things like, oh, if we're not going to give it out, then let's just give it away, or let's break up the trust, and let's get these lots out. So I think anything we can do to accelerate the leasing of the lots and prevent the corruption that we have seen with the Chamorro Land. I've reported on some of this corruption, right? And it's unfortunate, Mr. Chair. I hear what you're saying. We have rules and regulations, but then if somebody has a special interest, who do they come? They come to us. They come to the legislature, and they ask us to circumvent, a lot of these processes. So I'm very grateful for your service, and I think that we have the right man at the helm to lead these changes. And of course, I commend Speaker Terlaje on her hard work with this committee. And that's it. Nothing further, Madam Chair.
Senator Barnett. Can I clarify a couple of things? So first of all, according to the law, the applicant and the lessee, either of them, are supposed to designate who's going to be the successor, right? So that's the number one priority, is try to get them to designate. They're supposed to do it at the time of application. Hopefully your staff, when they're reviewing the application, say, hey, you didn't designate, right? That's how you get rid of the problem Senator Taitagui is suggesting. In the absence of those, of course, you have some applicants that have been sitting for a while, but when they come back up, do that again, right? At every opportunity, try to get a successor, so we do not end up in that situation where you have to decide between successors. Although the statute provides that in the absence of a designation for a successor to a lease, to an actual lessee, that you're going to decide. I'm proposing that in the absence of a designation of a successor applicant, that we move on. I don't want the Chamorro Land Trust to be stuck looking for who are the heirs of this applicant if they did not put in a designation of a successor, and that you just move on to the next applicant, because we've got so many applicants, as the chair has so clearly demonstrated. And however, lessees, I agree with the original statute. You take a little time and you find heirs that were not designated. And in the end, that there is no beneficiary who qualifies, then you move on, right? So that's the statute. So I'm hoping this will make you a little bit more efficient in that regard. But of course, this all depends on your staff doing its job, making sure that we, evoke from these applicants who their designation is going to be. Do you agree? I want to thank Lydia Talu. She testified in her personal capacity, but my understanding is she's also an employee. And she noticed something that I could not find, so I want to thank her. So, and that is when the GAR, the rules, were codified, there was an error. And so they deleted the previous rules about successor applicants. But my proposal is to amend that as well, not to reinstate it, but to say no successor applicants if you didn't designate. We just move on. So maybe discuss that with her. I'm looking forward to your input on any of those suggested changes. But can I ask you something? So what do you think about removing the widow or widow and widower of the brothers and sisters. So we're going to try to include siblings now. So your brothers and sisters can be a successor. But what do you think about removing widow and widowers of brother and sister, your in-laws?
Just to add in on the, if we recall the lawsuit of that district court,
Yes.
I think it's 17-00113, where the Fair Housing Act requirement. So perhaps maybe some of the widows or widowers are non-CHAMORRO or non-qualified. So, but this is for successorship, right? But just to add that even if the widow or widowers not a qualified applicant, that they have the federal constitutional right to remain in the dwelling as just for being there in that home, the Fair Housing Act requirement of 1968. So,
For spouses, the law provides, right? So if your spouse, you're supposed to only, the successor is supposed to be qualified, same eligibility rules apply, except they made a big exception for spouses of the actual lessee. So a spouse can have a life estate, right? But that's not the case for widows and widowers. And Lydia had suggested we just remove widows or widowers of brothers and sisters. Not your own widow, but brother and sister's widow. What do you think? Anyways, think about that. That's something else. If you could please get back to me on that, I'd like to know. And then finally, I was thinking, you know, successors going down, but of course, I totally see the logic in including parents. I'm stunned that that wasn't in there. Parent. There was a suggestion by the director to include grandparents. I see no harm in doing that, I guess. But there is, okay, so there is a line of succession as well, right? It says you're going to designate in this order, and so the order is, it would be the spouse first, children, grandchildren, parents, siblings, widows or widowers of the children, that would be your daughter or son-in-law, or widows or widowers of the siblings, or the nieces and nephews. Do you agree with that order? That's on the page 1 of that draft on line 10. Anyways, or if you could look at it on your own time, just get back to me. So that's what I'm proposing to be the order. If you think there should be a different order, let me know. And I think we're really fortunate to have your expertise. Joey, you've been at this land trust how many years now?
Since 1998.
98?
Yeah.
1998 is 3 years after the 1995 applications were open, thanks to the late Angit Santos, and of course, C. DeBitt, and all of the team really advocating that those rules be passed. Were you a senator at that time, Senator Brown? Senator Brown.
The original law was passed by Paul Berdalio, I believe.
Yes,
right,
in
when he was a senator,
1975.
and yet we had to come back in during the time when Angit was, prior to him becoming senator, to actually get it implemented. I know
Yeah.
you guys were very active with that. It started with, you know, when you were there during Joe Adams' administration, then after we got elected to the legislature, there was a big presence at the legislature to push forth to actually get the land trust implemented and in place. Because prior to that, it was in law, but not implemented.
Interestingly, these were not the rules that were proposed at the time. And it was National CHAMORRO that came in, a great presence, as Senator Brown said, and advocated that the rules be different, and these are the rules that we see today. So they do need to be, tweaked a little bit. After all those years, we see the gaps, and so I want to thank you for all your work in that, and to continue to work with me and my colleagues. And thank you for your questions and testimony this morning. I hope you can assist me in moving this forward. Any other final comments, Mr. Chair?
Just a final point is that when we were mentioning about 12-226, that the CHAMORRO was that the Land for the Land Use program was the major catalyst that kind of motivated us to come in and implement the CHAMORRO Land Trust Commission, because the Land for the Land Use program, as we all know, what it did is that it sliced a major portion out of the inventory, and the qualification criteria at that time was that you just have to be basically landless. But then we have to go back one more step back before the Land for the Land Use, is that we had the land use program. And if I may respectfully ask for the body to analyze the people that were provided the land use permit back in, I think that's Public Law 40 at that time, right under this roof again, is that it was, the land use permit was to address those people that have had, as a Category 1, had all their properties condemned by the federal government. And then it went to Category 2 for those applicants that have had at least 50% of their properties taken. And then you have Category 3 that established the Department of Agriculture long-term lease. And these are some of the leases that we see today that are now under the CHAMORRO Land Trust that had, like, I believe, a 50-year lease. And many of them had occupied properties from 20 acres to 50 acres, and I believe up to 100 acres. And some of those leases under the Department of Ag are now coming close to expiration. So that was just a note to add in of what triggered the 1995 protests, is to save the properties from being distributed under that unfair program, shall we say, with the Land for the Land Use program. That's it, Madam Chair.
Mr. Chair. There being no further questions or comments, we will close on the bill. This hearing is hereby adjourned.